and comments for the appropriate segment. Good morning, everyone, and a very warm welcome to the inaugural session of the National Bail Advocacy Competition 2026. I am Nivedita, and it's an absolute privilege to be with all of you this morning as we officially open India's first national level competition dedicated entirely to bail jurisprudence and criminal litigation advocacy. To every participant joining us today, you've already cleared the first hurdle by submitting your round one materials, and that took real work. So before anything else, take a moment to be proud of that. Over the next few weeks, NBAC 2026 is going to test your legal analysis, your advocacy, and your composure before a bench. It's not a mooting exercise in the usual sense. It's a simulation of the real thing. And we are thrilled to have all of you here for it. With that, let's begin. I'll now invite Disha to take us through the welcome address. Over to you, Disha.
Thank you, Nivedita. Good morning, ladies and gentlemen, respected chief guests, distinguished members of the bar and the bench, esteemed judges, faculty members, mentors, participants, and our honored guests. On the behalf of Collective Council, it is my privilege to welcome you all to the inaugural session of the NBAC, National Bail Advocacy Competition 2026. At the Collective Council, we believe that the making of a lawyer does not include with the study of law. It begins with the disciplined practice of it. It is the belief that inspired the National Bail Advocacy Competition, a platform designed to acquaint aspiring advocates with the practical realities of criminal litigation and the constitutional principles that govern personal liberty. Bail jurisprudence lies at the heart of a criminal justice system. It is where the state's duty to investigate intersects with individuals' right to liberty. Through this competition, participants will engage with delicate constitutional balance by analyzing complex factual records, preparing professional bail memoranda, and presenting arguments before experienced member of legal fraternity. We are deeply grateful to our chief guest, our distinguished judges, and every mentor who has generously agreed to share their time, experience, and wisdom. Your presence lends immense value and credibility to this inaugural edition. To the participants, I congratulate each one of you. You are not merely taking part in a competition, you are practicing in an exercise that seeks to cultivate discipline, advocacy, professional responsibility, and respect for the rule of law. With these words, I extend a warm welcome to all of you and wish every participant the very best for the competition. Thank you. May we now formally commence the inaugural session of NBAC 2026.
Thank you, Disha, for the warm welcome. I now invite Akansha to give a brief idea about the Collective Council to our participants. Please, Akansha.
Thank you, Nivedita. A very good morning to all our respected members of the bench and the bar, distinguished guests, esteemed speakers, members of the legal fraternity, our partner organizations, members of the organizing committee, dear participants, and everyone joining us today. It is my privilege to introduce the organization whose vision has brought all of us together today, the Collective Council, or many of us know it, TCC, the strength of any justice system. Ultimately, rest on the competence, integrity, and preparedness of the professionals who uphold it. While legal education provides the foundation, the journey from becoming a law graduate to becoming a trusted legal professional is shaped by experience, mentorship, and continuous learning. The Collective Council was founded upon a simple belief that legal education must ultimately produce professionals, not merely graduates. A law degree may confer eligibility, but it is meaningful practice that builds competence. With this conviction, TCC is building a professional learning ecosystem that brings together students, practitioners, mentors, law firms, judges, academicians, and advocates to create a vibrant, inclusive, and innovative ecosystem. Research initiatives, collaborations with universities and law firms, and a range of legal competitions. TCC creates an environment where aspiring lawyers develop not only legal knowledge, but also professional judgment, confidence, and the practical skills the profession truly demands. At the heart of this vision, a commitment to making professional opportunities more accessible, particularly for first generation lawyers who often begin their journey without the advantage of being established networks or institutional guidance. Every initiative of the Collective Council is guided by its constitutional values of liberty, equality, and fraternity, and by the belief that merit must always find opportunity. We are delighted to have each one of you with us today, and we sincerely hope that your association with the Collective Council through the National Bail Advocacy Competition 2026 marks the beginning of a meaningful and enriching professional journey. With that, I now invite Nivedita, who will take you through one of TCC's flagship initiatives, the National Bail Advocacy Competition 2026. Nivedita, please take it forward.
Thank you, Akanksha, for that introduction to the Collective Council. That gives everyone a good sense of who's behind the NBAC. I'll take it from here. As all our chief guests have joined, let me take a few minutes to tell you what NBAC actually is, for anyone who's still getting familiar with it. The National Bail Advocacy Competition is organized by the Collective Council and it's built around one simple observation: bail advocacy. Bail advocacy is one of the least formally taught areas of legal education in India. Law schools teach doctrine very well, but very few give students the chance to actually argue a bail matter the way it will exact gap. It runs around across three rounds. First, a written bail memorandum, then an oral advocacy round, and finally a grand bail hearing simulation before a judicial panel of practicing advocates and criminal litigation experts. This is the inaugural edition. So, in many ways, everyone in this session today is part of something, the first of its kind in the country. We're glad you're here for it. Now, let's move to introducing our dignitaries for today. I'll hand over to Palak to introduce our chief guest.
Thank you. It is my privilege to introduce our chief guest for the inaugural session of the National Bail Advocacy Competition 2026, learned senior advocate Shri Sanjeev Pratap Rao Kadam, High Court of Judicature at Bombay. A distinguished alumnus of the Government Law College, Mumbai, Senior Advocate Kadam enrolled with the Bar Council of Maharashtra and Goa on 26 July 1989. Over a legal career spanning more than 37 years, he has established himself as one of the most respected members of the Bombay Bar. His practice before the Honorable High Court has encompassed a wide spectrum of criminal and constitutional matters, including bail, quashing of proceedings, preventive detention, externment, discharge, and criminal revision applications. He has also appeared extensively before the Sessions Court, Metropolitan Magistrate Courts, and special courts handling matters under both the Indian Penal Code and various other statutes. In addition, he has represented several public institutions, statutory authorities, educational institutions, charitable trusts, hospitals, and cooperative bodies. He has also served the state as additional government pleader in the writ cell of the appellate side of the Honorable High Court of Bombay. Equally remarkable has been his contribution to the legal fraternity. Through his service to the Advocates Association of Western India, first as member, secretary, and vice president, and later as its president from 2019 to 2024, he has played an important role in strengthening one of the country's oldest bar associations. In recognition of his outstanding professional ability, integrity, and contribution to the administration of justice, the Honorable High Court of Judicature at Bombay designated him as a senior advocate on 14th January 2026, an honor reserved for advocates of exceptional distinction. For every participant of NBAC 2026, the opportunity to learn from a lawyer of his stature is both a privilege and an inspiration. His presence reflects the very values that this competition seeks to cultivate: professional excellence, disciplined advocacy, ethical practice, and an unwavering commitment to the rule of law. On behalf of the National Bail Advocacy Competition, it is a proud privilege to extend a warm and respectful welcome to learned senior advocate Sri Sanjeev Kadam. Sir, we are deeply honored by your gracious presence. May I now respectfully request Senior Advocate Sri Sanjeev Pratap Rao Kadam to kindly address the gathering and formally inaugurate the National Bail Advocacy Competition 2026. Sorry, sir, you are on mute.
Good morning, everybody. Now, can you hear me?
Yes, sir.
Yes. Uh, Dear members and the organizers of the Collective Council, all the participants, junior lawyers, and the students of law, it is a great pleasure to be invited for inauguration of the Collective Council. I was happy to learn that the members joining here are the first generation lawyers. I feel proud to be one of you because I am also a first generation lawyer, having no background in my family about law field. Though now, after me, with me, my son has also completed law. But there was nobody in my family earlier when I joined the law. It is always tough for a first generation lawyer to start practice and to establish himself in the field. However, challenges make the man more competitive, more tough, and more able to fight with any situation that comes across. No doubt, the destiny manages to get you good seniors, though you don't have contacts. As far as started my practice in 1989 and started it from the Sessions Court at Mumbai, and the lower judiciary. Always, I have seen the new generation rushes to the High Court. They want to practice in High Court. There's nothing wrong in that. However, unless you know the real procedure and the niceties of the practice in the lower courts, many times you come in difficulty when the questions are asked by the bench about the practical situations in the lower court. How many of us know how the surety is passed? Nowadays, it is the power was in Mumbai, as far as Mumbai is concerned, the power was with registrar, who was equivalent to a magistrate. Then there are so many small works or minor works which you can call in the lower judiciary, which teach you the practical niceties of the field of law, especially if your topic is about bail. Bail is a concern of people because somebody is inside, somebody is arrested, and somebody is detached from his family. Therefore, the whole family rushes to a lawyer and requests, get our man out on bail, get our woman out on bail. So, bail is an important facet of a criminal law. Of course, it is also a paying field for the lawyers because in civil litigation, people can wait for the verdict to come out. But in criminal litigation, that can't happen. Criminal litigation, the person, if he's, especially if he's innocent and he hasn't done anything, he really gets frustrated by the illegal arrest or the wrong accusation. And then he feels, what is the system of law that I'm sitting in jail and nobody is taking care of mine or nobody is bothered to even hear my plea. And therefore, our courts have time and again let down that bail pleas have to be heard expeditiously. Persons cannot be languishing in jail without being heard. That is the basic law. And as you all must be knowing, our basic jurisprudence has laid down that a person is not to be considered as guilty unless he is proved to be guilty. However, bail curtails your liberty. Bail curtails liberty of a person accused of some offense. The trial, which will give a verdict whether the accusation is right or wrong, false, etc., will it take its own time. But what happens in the period in between? And therefore, bail is an important aspect of law, which is your topic for the day. Now, you have further categorized this topic as bail qua economic offenses. As we all know, body offenses were on high side earlier era. Nowadays, economic offenses have captured the top position as far as criminal offenses are concerned. Time and again, we come across new methods of cheating, new accusations, and new defenses. Now, economic offense is a facet of life as on today. We learn, and I don't know how many of us might have come across. Cyber crime is in high rise. People get calls, people get cheated, people get threatened, people get arrested only on the calls, no physical arrest. But they are threatened that such and such parcel is come in your name and the courier has come in your name. You are the sender and there is drug inside. And if you and the poor people who are not aware about the law, they get frightened, they get pressurized. Now, yesterday I came across an example where a person received a video call from an unknown number. Normally, nowadays people should follow that. Don't answer the unknown calls unless you are sure who is that. This chap answered that video call and a beautiful lady appeared on the other side, smiling face. And this man was a bit innocent type of person, straightforward. He said, I think it's wrong number. She says, no, 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 no. It's not wrong number. I want to talk to you. Then they talk for 5, 10 minutes and the call gets closed. Next day, he gets a video clip where he is found to be in uncompromised position with that same lady who had called. And then the great start. If you don't pay this much, this will be made viral. Now, if you have a status in society, naturally a person will get under pressure that what will happen in my family, what will happen in my office. If it's an advocate, what will happen in the bar, how the judges will look at me. And then that pressure, a person loses his sense to take recourse of law. And then he succumbs to the pressure and pays the ransom. But the demand doesn't stop, it goes on. Several new such methods are being innovated by the culprits, by the criminals, and people fall prey. Same is the case of instances. How many of we remember Kalparuksh scheme of investment? Gone are the days when Kalparuksh was an investment scheme. Similar schemes, Ponzi schemes are floated by many companies, even till today, and people fall for it. Though they read news about these in newspapers, though they come across articles about it, but still the lust for the money and fast money lure the people to enter into such Ponzi schemes. You invest this much, you'll get double in 3 months. How is it possible? Bank do not give you 4%, 6%, 7%. How the investment company will give you double in 3 months, 4 months, 6 months? It's not possible. What is the rate of double being in the bank? 7 years and above, I think nowadays, or 8, 10 years, I don't know. But people fall for such schemes and they invest, and when they find, and there is a typical modus operandi. These firms give you return initially, 2 months, 3 months, 4 months. Then you feel happy. Oh, I'm getting good return. Then you invest more. Then you invest more. And then one good day, after 6 months, 7 months, or a year, the scheme stops, payments stop. And then all rush to police, MPID Act. We are cheated. We are cheated. We are duped. But where were you when you accepted such spongy schemes? Was your brain not working? Some of the judgments criticize this tendency of society. But as a lawyer, people come to us and they say, we are cheated. Same time, accused go to the lawyer, get me out on bail. I've not done anything wrong. I gave good schemes. Suddenly, this money stopped coming in, so I could not repay. But that's a civil liability. That is what we argue. It's not a criminal case. That what lawyers argue. Now, that is exactly what your topic is about, bail qua economic offenses. Now, economic offenses initially were dealt with penal code provisions like 406. I'm talking about the IPC, 420. If it is between a master and servant or a banker and agent and all that, then 409. Then many times these economic offenses are also tagged with forgery, inviting offenses under 465, 467, etc. Subsequently, the legislature realized that we need to have special laws to curb these activities or to punish or to deter the people from committing criminal economic offenses. And therefore, the special laws came into force, like MPID Act, PMLA Act, Prevention of Money Laundering. Now, MPID Act is a state act. It was challenged, its constitutional validity was challenged. Subsequently, Supreme Court held that it is constitutionally valid. The people or persons covered under the Act, the arena is wide. Not only the promoters, directors, but also the agents or any person involved in the scheme and inducing the people to invest is liable to be charged under MPID Act. The spectrum is wide, and there is a mechanism of recovery also in this act. Because merely punishing a person is not sufficient for the persons who invest their hard-earned money. With that view, competent authority was provision was made in the act. Attachment provisions are made. After attachment, auction can be made, and the intention of the act is to at least return the basic investment of the person who has invested and been cheated. Now, our target is to ensure that Act provides for recovery. Whether courts can be a recovery court in MPID or these economic offenses is also a hot issue to be discussed. Many judges have an opinion that if you want bail, deposit this much. Quite often we come across. But Supreme Court has also said that bail court is not a recovery court. Bail court has to see basic things. What is the gravity of offense? What is the prima facie material against the accused? How much time he is in custody? Are there any similar antecedents against him? Is there a possibility that accused will flee from justice? Are the criteria to be considered for bail? However, the tendency is that, and nowadays there is activism from the victim side also. As the law has now recognized victim to be a active part of the judicial system, every case literally, the informant or the victims are represented by lawyers and they are bent upon recovery. They are not interested in custody of the accused. They are interested in recovery. No doubt we appear for accused as well as complainant in many cases. But this is what is the bare fact. However, the courts are not that stringent in economic offenses, are not strict as the court is in heinous offenses against body. Because society doesn't treat economic offense as an offense against society till now. But if a minor is raped, If an old man is killed, if a lady is killed, or if a lady has been tortured, kidnapped, then the society takes cognizance. Media raises voice. That cases taken as offense in society. But economic offenses, normally the society doesn't react because who is not victim, he blames the victim. Ah, so he invested. Let him face. This is the approach. And therefore, compared to heinous offenses under the penal code, economic offenses are not considered that serious by the society, and which is, of course, reflected in the judiciary also. After all, what is judiciary? They are among persons coming amongst from us only. They are initially lawyers, then developed their practice either on the government side or on the defense, and then they are taken up as judges, or they appear in the examinations conducted by MPSC for lower judiciary for assistant district judges, all that cadres, and then they get selected. But basically, all of them come from lawyers. So judges also don't, many of judges don't treat it as serious as body offense. Of course, each judge has his own view. Some judges treat body offenses as serious. Some judges treat economic offenses as serious. Because some judges feel and they have their opinion that economic offenses not only ruin the victim, but it ruins the whole family. Because if a person, the main person in the family, he invests his hard earned money in a spongy scheme and loses it, the whole family suffers. It has rather great impact on the family. So there are such socio-economic aspects. As far as bail is concerned, our law says bail is rule. Jail is exception. But considering the higher volume of cases, courts are reluctant to grant bail easily. You have to make out a case. Now, what way you can make out a case? Many of these cases, apart from the main accused, like company who cheats people or who induces or who floats the spongy schemes, the agents, everybody was accused. Many cases, these agents, so-called agents, are also investors in the same scheme, but they are made accused. But you induce people, you participated in the or seminars, etc., etc. These are the common allegations. But the question remains: if you can't conduct the trial within a reasonable period, how much time a person can be kept in custody? Situation in our jails is pathetic. Reports of different committees have pointed out that in a capacity where 10 prisoners can be kept, 100 prisoners are there. So bail has impact of this factor also. How would you accommodate such a large number of accused in the jails? So again, it comes to infrastructure. Judiciary system is not only justice delivering system. It is associated with police machinery, establishment of courts, establishment of jails, establishment of remand homes. Now juvenile offences are also on rise because the generation is very fast to adapt with the mobile, iPad, laptop, etc. And they are open to internet. So some brains work on how to misuse it. And therefore, even in cybercrime or economic offenses, you will find juveniles getting involved. And in that case, you have to have reform homes. You have to have juvenile courts. You can't deny justice to a person just because your infrastructure is weak. And that is exactly where Supreme Court has laid time and again that long incarceration, a person is entitled for bail without going into merits of the matter. And that seems to be the trend and law. However, fact remains that what happens if a person who is not connected with the crime actually, or if a person is innocent and he languishes in jail for a year or two, what would be his mindset? He might either turn as a hardened criminal or he will get frustrated. Therefore, the basic jurisprudence nobody should forget that a person cannot be labeled as guilty unless he's proved to be guilty. Nowadays, people are forgetting it. Many times media says, hang him, finish the trial within 1 month, hang him. But suppose he's innocent. Therefore, the law said, we will allow 99 guilty to go scot-free, but one innocent should not be hanged. That is the basic principle of our criminal jurisprudence. There is no need to be afraid of definitely one he has no right to complain unless he gets acquittal in appeal. However, before trial, you cannot keep a person indefinite time in jail without being tried. That is the basic principle. I congratulate the Collective Council for organizing such event. I also wish, I think I have spoken for more than 30 minutes. Thank you for hearing me. And I wish all of you the best in the field of law. Remember, you have to fight for a person considering him to be innocent. Never try to judge a person coming to you. You are not a judge, you are an advocate. The person comes to you and you are the mediator between him and the God sitting on the bench. You have to plead his case the best way you can. Never try to ascertain whether he has really committed the crime or not. If you try to become a judge before you act as an advocate, you will not be able to defend him properly. So, as jurisprudence lays down, bear in the mind, person is held to be innocent till he is proved guilty. So any client coming to you, you have to try your level best to get him bail out, to get him acquittal. You are not concerned whether he has committed the crime or not. Never go moral on this issue if you want to practice a defense advocate. You have to try the best for that man coming to you. He might have committed a mistake. He might have committed a crime or not. We do not know. He and the God knows. And therefore, the judges are left as my Lord. And you have to plead your best case for your client to the Lord, to the God, and leave the decision to the judge. You are just a mediator between the judge and the client to argue out his best case. That's all. Never take it as personal. Second principle, never take it personal. Cases will come and go. Never get much involved. You have to act independently as a lawyer without being influenced by any emotions or any promises. Once a case of a client is taken, he is your client. Never talk to other side unless your client wants. About the case, you have a duty to make an attempt to settle, but that too also on instructions given by your client. These are the basic principles of the criminal law. I wish you all the best and thank you for inviting me. I was happy to join and be amongst you all. Thank you. Good day.
Thank you so much, sir. It means a great deal to have someone of your standing take the time to address our participants directly. And I know the perspective you shared with us will stay beyond today. We're genuinely grateful you're with us today, as I believe many of us are going to be first generation lawyers. Hearing you overcome your struggles and experiences you shared us with today inspired us deeply, and thank you for sharing insightful tips.
Thank you.
Now, it's my pleasure to introduce learned advocate on record at the Supreme Court of India, Mr. Tushar Khairnan sir, also the great guest of honor of today's event. Advocate Tushar Khairnan hails from Nashik and completed his law graduation from DES Law College, Pune in 2016. He began his legal career in Pune under the guidance of Advocate Jayant Kalbur, practicing before the Pune District and Sessions Court. Later that year, he moved to Mumbai and worked with Advocate Umesh M., gaining extensive exposure to litigation across the Bombay High Court, Sessions Court, Ministry Matters, Cooperative Courts, and the Maharashtra Administrative Tribunal. In 2018, he began his independent practice in Mumbai, appearing regularly before the Bombay High Court, Bombay Sessions Court, Kurla Sessions Court, Kalyan courts, and authorities like Cooperative Society Registrar across civil and revenue matters. From 2022, he shifted his focus towards Supreme Court practice, cleared the Advocate on Record examination in 2023 on his first attempt, and today practices primarily before the Supreme Court of India alongside the Delhi and Bombay High Courts, with a strong focus on constitutional law and appellate advocacy. Sir, thank you for being with us today and for everything you and the team have put into making NBAC 2026 possible. May I request you to kindly address the gathering, sir?
Firstly, I would like to say sorry to all because this unfortunately due to the commitment, I'm not in my office, so it's just like in a cafe. I'm connected with you, so just want to say sorry to all. Um, it's actually being team with the collective council from the 1.5 year. I really would like to say thank you to them. That's a great initiative and making efforts to understand law student about the bill jurisdiction and when and how the bill need to file and then how it going to be argued and how the jurisdiction exercised by the any person because mostly client or the accused not even aware about it that the how it going to be happen and then something like this. But through this, I would like to when you are coming to the practice, coming to the litigation, you guys will aware about it that the how the jurisdiction will be exercised and then how it will shape your practice with that knowledge when you are going to be initiate your initial years of the litigation, even though it's like you're going to be litigation or you're going to be firm practice, but still you must aware about that how the jurisdiction is required. Yeah. First, we have to go in a question by question. So there's a one question for me, I guess. Wait. Can I just read the questions or just repeat for me? What exactly you want to know about the bill jurisdiction? It's better actually. I will address to all, so it's better that you guys will get a better idea that the what exactly bill jurisdiction is about, and then how it's going to be actually executed before the session court, high court, and the before the Supreme Court. So it's a very busy jurisdiction about the bill jurisdiction about the when there's a two type of bill. It's a anticipatory bill and then regular bill. Anticipate is a before arrest, and then regular bill is of the after arrest. So there's a another two stage about it. First is FIR, then investigation happen, and then a filing of the charge sheet. So it would be make a different scenario in every case, irrespective of the seriousness of the offenses, irrespective of the nature of the offense, then character of the accused. It make difference, but the most important thing is about in a bail jurisdiction. Most importantly, is about the whether accused going to be absconding, whether he having a root in a society, and then most importantly, whether he going to be involved into a trial, like the whether he going to be his non-presence in a jail will impact to the trial. These things are very important while deciding the bail application. So for the anticipatory bail, it is like the PRS bail, and mostly it filed before the session court only, and then other bail, just like in a trial court where the actual trial pending, where you need to apply for the bail application. Then second stage is very important. If session court or JMFC court or district court, whatever, where the trial pending, if they refuse to give it the relief in a regular bail or even in an anticipatory bail, then there is a second provision is about you can approach to the High Court to getting the same relief in the same jurisdiction. And then third and the last jurisdiction exercised by the Honorable Supreme Court under Article 136. That's a ultimate and then final jurisdiction while exercising the bill. So it is come under the Article 136 where you ask for the leave, and then in that leave jurisdiction you ask for the bill. So it might be different. It comes under the constitution, but very rarely it happened that the if the bill application denied by the session court and denied by the high court, very rarely Supreme Court going to be involved into it and then try to change the decision. So probably it is all depend upon the what argument you place before the session court. It will continue till the final outcome of the jurisdiction. Out of this, actually, what argument we need to place before the court, like irrespective of the fact, irrespective of the nature. Uh, I feel so. While arguing the bail application, you rather than focusing on a seriousness of offenses, you need to focus on a under what circumstances you can place your bail application, and then you ask for one thing like the if even though bail is granted, you are not going to abscond. You're going to be attend the trial each and every day whenever the trial is required, and then most importantly, you cooperate for the investigation. So in that way, our argument must be rather than just fact. It's about the how and when the jurisdiction need to be exercised, and then most importantly, if even though bail is granted by this court, I'm not going to misuse that power. That power. So that's only most important thing and basic thing we need to focus while the arguing the bail. Yes. Because bail usually very limited one, rather than just fact, it is most important to argue on a why bail need to be allowed, like a health issue, role played by the accused, and the most importantly, you're not going to abscond if the bail is granted. And this is the main motive behind this competition that you need to while the arguing the bail, you must argue the on a thing like the why is bail need to granted. Secondly, if granted, you're not going to misuse that power. So this is what exactly we expecting through this competition from you. Yes. So it's a very simple switch, and then I would like to say all the best to all the team, and then looking forward that we are going to be I'm looking forward all of you in a that manner that you guys are prepared thoroughly, and then allow to judge all of you in that way. Yep. Any question for me?
Thank you so much, sir.
Yep. Okay. You guys can continue. I have another commitment. So, any question for me regarding competition or anything?
सर क्या हम एक क्वेश्चन पूछ सकते हैं
Yes, yes. आप पूछ लीजिए क्या पूछना है आपको?
सर जैसे एक तो कॉग्निजेबल एंड नॉन कॉग्निजेबल ये होता है
ठीक है.
तो उसमें जैसे नॉन कॉग्निजेबल में आपको बेल नहीं मिलता है
Okay.
बट मैंने देखा है बहुत लोग जैसे रेप कन्विक्ट एंड और मर्डर उन्हें बेल कैसे मिल जाता है फिर सर
Exactly. That's what
कौन
I'm
से बेसिस
telling
पे
you now.
बेल
Yeah,
मिलता है उन्हें
it's not it's not about the offenses. जैसे मैंने स्पीच के इनिशियली ही आपको ये चीज बताई थी. It's not about the offenses. It's about आपका रोल क्या है उसमें, and then about the what evidence against you. That's the most important thing. And then most important, if bail is granted to you, क्या आप उससे misuse करोगे उस order को? If those circumstances are in your favor as an accused, तो आपको bail मिल जाती है, irrespective of the offense.
ओके ओके सर और सर मतलब हेल्थ इशू ये सब पे भी बेल मिल सकती है
काफी it's actually our first point of argument. हम कभी भी facts के ऊपर argument नहीं करते bail में. We are on a point कि मुझे जेल के अंदर अगर रख दिया तो मुझे health damage हो सकती है. और सेकंड थिंग हम मोस्टली आर्गुमेंट हमारा ये होता है कि अब इवन तो मुझे बेल अलाउ कर दी तो मैं एब्सकॉन्ड नहीं रहूंगा क्योंकि मैं आई एम अ वेल रेप्यूटेड पर्सन इन अ सोसाइटी. That's the most important thing. So it's very basic theory of while arguing the bill. First, go on a health issue, then family dependency, your sole breadwinner in a family, and then other things we need to add on. So it's not about the seriousness offenses. It is about the if bail is granted, you are not going to misuse it. That's the most important point for the argument of the bill. Okay.
Okay, okay. Thank you, sir.
Yep. So you guys can. So thank you, team.
Thank you so much, sir. Hearing your journey from a district court in Pune to arguing before the Supreme Court is exactly the kind of grounded, real world perspective a participant need as they prepare for their own careers in litigation. We really appreciate you sharing your thoughts with us, sir.
Thank you. Thank you so much, team. Thank you.
It's now my honor to introduce our founder, Mr. Yashwardhan Rane, sir. Yashwardhan, sir, is the founder of the Collective Council and a first generation legal professional committed to building institutions that make the legal profession more accessible, inclusive, and practice oriented. Guided by the constitutional ideals of liberty, equality, and fraternity, he believes that every aspiring lawyer, irrespective of background or privilege, deserves meaningful access to mentorship, practical legal education, professional opportunities, and a community that enables merit to flourish over inherited advantage. His vision is what brought NBAC to life, and it's a privilege to have him address us today. With that, I have the honor of inviting Yashwardhan sir to share a few words with us. Please, sir.
Thank you, Nivedita. Good afternoon, everyone. I hope there are participants, there are preliminary round judges that are present with us today. Uh, First of all, I would really like to congratulate the organizing committee for organizing such a beautiful competition. I would also like to be grateful towards Chief Partnership Officer of the Collective Council, Ankit Kuril sir, and Palak Agarwal, who basically came up with this brilliant idea where students could get hands-on experience in the initial code practice. Mostly what moot courts take place in college are far away from what actually happens in a lower court, and lower court is where actually a graduate starts the initial practice. So to bridge that gap, the collective council has came up with NBAC 2026. This is the first edition of the competition, and we have received an immense response and we are proud to host many colleges from all over India and participants here. We are very much honored to have with us today for the inaugural function senior advocate Sanjeev Kadam sir and forever our back advocate on record Tushar Khairnar sir. It is really delighted to have so many eminent personalities here with us today for the inaugural function. I wish all the very best to all the participants that are there. I won't take any long because the competition pace is very fast. A lot of the material that will be given to you is given to you at the last moment on purpose, considering that is how the situation is when you practice at the trial and the session courts initially. So, wishing you a very best of luck, and once again, a very grateful to all the participants who participated, to the organizing committee and the judges who have taken up the responsibility to guide these young legal minds during these competitions and help them out at various stages. There are a lot of people amongst the preliminary judges who are also mentors with the collective council, are educators, and have played various roles with the collective council community for a longer period of time. We have Nitish sir, we have Sahil sir, we have Durga, who's been working with us at the initial stage and the foundation of the collective council. It's really great to see you back, Durga. Then we have Dhruv, who's been with us always since the beginning. Uh, there are a lot of other eminent lawyers and educators and mentors that we are glad to host here on the occasion of the competition today. We have Advocate Shivam Kumar sir. And if I've missed anybody's name, apologies for the same. However, we are really honored to have each one of you here. I hope the hospitality here at the Collective Council feels you warm and homely, and you stay connected with the Collective Council for the time to come. Many Best wishes to all the participants that are going to participate in the competition, and let's make NBAC 2026 the most successful competition of the year. Thank you once again. Thank you for giving me the opportunity. Best of luck.
Thank you so much, sir. Hearing the vision behind NBSC directly from you is a reminder of why we are all here today. To give bail advocacy the serious space it has long deserved. That means a lot coming from the person who made it happen, and definitely we're gonna make NBSC a grand success. Before we move ahead, I want to take a moment to congratulate every single participant who has submitted their bail memorandum for round one. Getting a memorandum together within the given timeline, under words limit, with proper citations and formatting, while still building a genuinely persuasive argument isn't easy. Every one of you have managed that. So well done, and thank you for taking this competition seriously from day one. On that note, let me share an important update. Results for round one, that is the written bail memorandum round, will be announced on 21st of July. We will be sending this out as an official communication to your registered email address. So please do keep an eye on your inbox. Now, before we close, let's go over a few important instructions. Keep monitoring your registered email address. All official updates, including results and next round details, will come through there. If you are shortlisted for the semi-final round, you will continue in the same role, defense counsel or prosecutor, that you were assigned in round one. Please do not share your written bail memorandum with other participants until the competition ends. If you have any question about the competition, please route them only through the official competition email address. Direct communication with any member of the evaluation panel isn't permitted. All right, that brings us to the end of the session. Thank you all again for joining us today, and best of luck as you await the round one results. With that, I'll hand over to Nidhi for the vote of thanks and to formally close today's session. Over to you, Nidhi.
Thank you, Nivedita.
Ma'am, do we just
Now I shall conclude with the vote of thanks. Respected chief guest, guest of honor, dignitaries, esteemed judges, organizing committee, and our dear participants. I am Nidhi, and it is my privilege to propose the vote of thanks as we conclude this momentous inaugural session of NBAC 2026. India's first simulation-based national criminal bail advocacy competition. Today marks the beginning of a journey that embodies the spirit of collaboration, excellence, and professional growth. Thank you, esteemed guests, for gracing this occasion with their presence and sharing their invaluable insights. Sir, your wisdom and experience has set the tone for this rigorous yet enriching experience. We extend our gratitude to Advocate Tushar sir, a brilliant mentor at the collective level, for guiding us through this complex process. Thank you, esteemed judges, participants, organizers, and members of the bench. Refine your drafting skills, master over advocacy, or gain exposure to real world legal challenges. This competition promises to be a transformative experience. Once again, thank you so much for making this session a success. Your presence and support are the pillars of this event. With gratitude and anticipation spreading across the nation,
for the rounds ahead, I conclude the vote of thanks. Thank you, everyone.
Ma'am, do we have certificate today? Any session like we have to fill any form?
Hello, Anuj. As I have mentioned, if you have any doubts, please direct it to the